Salutations, Coach Tate here with my court coach, and today we want to talk about the decision from the United States Supreme Court regarding whether or not Donald Trump can be kept off the ballot for the Colorado presidential election. And today the decision came down from the United States Supreme Court saying, no, Colorado cannot keep Donald Trump off the ballot. You're going to see some headlines in the news about it. And a lot of these takes are going to be political takes. And I wanted to go over what the legal decision is what the decision was and why, so you can understand it for yourself. So let's talk about that. I'm going to share my screen here. Let's see here. We might just mention that the Civil War ended in April of 1865. The 14th Amendment was adopted in the very next year, 1866. So let me share my screen here to show you sort of the background of this amendment. Okay, and I'll share a link to this webpage here. But you see, this gives the sort of the history or the reasoning behind the 14th Amendment. The history here, this was passed by Congress in June of 1866, ratified in 1868. So you had the Civil War, you had the southern states who were still very unhappy with the United States of America. And so these states could be electing individuals to be on the federal Congress, individuals who were not happy with the country and who were still not feeling unified with the country. And so this amendment was adopted to extend liberties and rights granted by the Bill of Rights to formerly enslaved people. That was the biggest part of it. The 14th Amendment has 5 different sections. The first section is the one that most people talk about, that you're most familiar with. It says that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. So remember that formerly enslaved people were made citizens. This says right here, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Huge deal, obviously. And then this sentence says, no, nor shall any state deprive any person of life, liberty, or property without due process of law. Okay, nor the equal protection of laws. Okay, that's section 1 that we're all familiar with. And then what this case is about is section 3 and section 5. And we'll go over those here in just a second. But let's take a look at the court opinion so you can understand what the court opinion is about. Let me share the court opinion with you here. Okay, I've marked it up some. Let me share that with you so that it's bigger. All right. I wonder if all right. So background is, in the state of Colorado, there were a group of Colorado voters who filed a petition against President Trump, the former President Trump, and Colorado Secretary of State Jenna Griswold in the Colorado State Court. These voters contended that after former President Trump's defeat in 2020 election, he disrupted the peaceful transfer of power by intentionally organizing and inciting the crowd that breached the Capitol as Congress met to certify the election results on January 6, 2021. So that was the argument, and this was litigated in the trial level, the lower level court in Colorado, and then in the appellate court, and then it went to the Supreme Court of Colorado. And this is the argument. Section 3 of the 14th Amendment says, no person shall hold any office under the United States who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So according to the people who filed this lawsuit, Section 3 of the 14th Amendment applies to former President Trump because after taking the presidential oath in 2017, he intentionally incited the breaching of the Capitol on January 6th in order to retain power. They claim, the people who filed this lawsuit claim that, therefore, Donald Trump is not a qualified candidate, and that as a result, the Colorado Secretary of State may not place him on the primary ballot. That is the contention from the very beginning, what this lawsuit was about. And so when it was litigated, the Colorado Supreme Court, accordingly, they agreed, and they ordered the Secretary Griswold not to list President Trump's name on the 2024 presidential primary ballot or count any write-in votes cast for him. And so this was appealed from Colorado Supreme Court to the United States Supreme Court. And the question that the United States Supreme Court was tasked to answer was a single question. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? And the Supreme Court said, concluding that it did, we now reverse. So they said, yeah, this Colorado Supreme Court cannot keep President Trump off the ballot. So let's go over an explanation as to why that was. When the courts are interpreting language in a statute, they want to interpret it in a way that the words that they're interpreting are going to, the words that they're interpreting are going to make sense within the broader framework of the act or the amendment. And so what the court did here is they started looking at what was the purpose of the 14th Amendment. And they said, going back here, this is highlighted in green. The 14th Amendment expanded federal power at the expense of state autonomy. So if you look at the First Amendment, the first section of the amendment, for instance, it bars the states from depriving any person of life, liberty, or property without due process of law, and denying to any person equal protection of the laws. And so the point of the Section 1 was to limit state power and instead to grant rights to individuals. Section 3 of the amendment was designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. So essentially, the reason why this is important is because they're saying that this lawsuit by these individuals is trying to increase state power when the whole point of the 14th Amendment was to limit state power and instead to give rights and powers to the individuals. So there you see some inconsistency of these voters who filed this lawsuit, their interpretation of Section 3 versus the whole purpose of the 14th Amendment to begin with. Let's continue looking at this at the decision here. I'm going to skip what I have in pink and we'll go to what's in blue. So what I want to do is just explain to you what the decision was, the reasoning behind the court's decision, which I've highlighted some parts in blue here. It says the Constitution empowers Congress to prescribe how these determinations should be made. So let me go back and look at the 14th Amendment with you here. So under the 14th Amendment, we just looked at Section 3, which was cited in the opinion of the court. Now go back and look at Section 5 right here. It says that the Congress shall have the power to enforce by appropriate legislation the provisions of this article. So the question is, is it only Congress that gets to enforce the provisions of Section 3? Or do the states also have authority to enforce the Section 3, which says that, hey, look, if you're an insurrectionist, you don't get to hold office? So that's the essential question. So let's go back and look at the opinion again. Now, it says the Constitution empowers Congress to prescribe how these determinations are made. The determination as to whether or not someone should be precluded from holding office after insurrection. The relevant provision is Section 5, as we just read, which enables Congress, subject, of course, to judicial review, to pass appropriate legislation to enforce the 14th Amendment, including Section 3 of the 14th Amendment. Section 5 casts upon Congress the responsibility of seeing to it for the future that all the sections of the amendment are carried out in good faith. The Constitution provided no means for enforcing the disqualification, necessitating a bill to give effect to the fundamental law embraced in the Constitution. So Congress would have to have a bill, which they would pass, and this bill would be the mechanism by which Section 3 would be enforced. And so the court is saying the enforcement mechanism, Champion, was later enacted as part of the Enforcement Act of 1870, just a few years later. And the court says this case raises the question whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 of the 14th Amendment with respect to the federal offices, especially the presidency. And it says further, the notion that the Constitution grants the states freer reign than Congress to decide how Section 3 should be enforced with respect to federal offices is simply implausible. State-by-state resolution of the question whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represents all voters in the nation. In other words, the court saying, look, if we were to allow each state to decide whether or not an individual is disqualified from being on the ballot, you could see all these different states coming up with all these different conclusions. Some states would say, yeah, this person is disqualified. Some person would say, no, this person is not disqualified, and it would be chaos. And so the court resumes. The result could well be that a single candidate would be declared ineligible in some states, but not in others, based on the same conduct. What I just called chaos, the court calls patchwork. The patchwork that would likely result from state enforcement versus congressional enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. Responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not with the states. So that is the decision of the Supreme Court. Now, the Supreme Court has 5 male justices and 4 female justices, and that is the per curiam opinion that we just read. You'll see that there are 2 attached opinions, which we will go over right now. Grab it here. Okay. There are 2 attached concurring opinions, and a concurring opinion means that, yeah, I agree with the decision being that Colorado has no right to exclude Donald Trump from the ballot, but they just disagree why. And so here's Justice Barrett says, look, I agree that states lack the power to enforce Section 3 of the 14th Amendment against presidential candidates. That principle is sufficient to resolve this case, and I would decide no more than that. And what she's saying is, look, all you have to do is say that the states don't have any power here because this is a federal election. And she wishes that the court opinion would have just stopped at that and said no more. And what she says here is this situation does not require us to address the complicated question of whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. So to reiterate, the court opinion says not only is it not for the states to decide, but of the federal government, it is Congress who gets to decide, who gets to present a bill and make the laws, which would be the enforcement mechanism. A new bill would be an enforcement mechanism by which Congress would decide how are we going to decide who would be qualified or who would be disqualified from office. And so she says, the court should not have addressed that. The court should not have said it's Congress's job only to decide, to establish the law, deciding who's disqualified or not disqualified. But she ends saying, look, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. And that is the message Americans should take home. I think the reason why she said this is she foresaw that there would be news outlets and people who would say, oh, look, you have these 5 justices who think one thing and then these other 4 justices who disagree. And I've already seen news headlines saying that there is a disagreement among the court. And her point is, look, we all agree the federal government gets to decide this, not the states. And then the other concurring opinion is by Justice Sotomayor and Justice Kagan and Justice Jackson. And they all say, in this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the ground that he is an oath-breaking insurrectionist and thus disqualified from holding federal office under Section 3 of the 14th Amendment. Allowing Colorado to do so would, we agree, create a chaotic state-by-state patchwork at odds with our nation's federalism principle. That is enough to resolve this case. So they agree Colorado has no authority whatsoever to keep Trump off the ballot for being an oath-breaking insurrectionist. And they too disagree with the court's decision to talk about how the federal government would make decisions about whether or not someone is disqualified. They're thinking, hey, maybe there's some other way in which the federal government could decide if someone could be disqualified from being on the ballot. And so last thing to go over is I wanted to explain why the courts emphasize the 5 justices emphasize that it has to be Congress. Now, let's go back to 9th grade or 10th grade or whatever grade it is. When we learn about federalism and the 3 branches of government and the checks and balances and separation of powers. Remember, in the government, you have the legislative branch of government, which is the legislature, and they're the ones who make the laws. And then you have the executive branch, which is in the federal government would be the President of the United States and all the agencies who enforce the law, IRS, the SEC, FBI, the post office, any agency that's part of the executive branch of government. And then you have the 3rd branch, which is the judiciary, the judicial branch. So the judiciary gets to interpret the laws. The executive branch gets to execute or enforce the laws. The legislative branch gets to make the laws. I think the reason why the court was explicit that, look, it's Congress who makes this decision is because the court was worried that the executive branch of government, right now headed by Joe Biden, it was worried that maybe the executive branch of government would try to take this power on itself, would think that it has the authority to decide whether or not someone who's going to be on the next ballot for president. They wanted to make sure probably that the DOJ or any other executive branch agency wasn't going to think that they could just take this on themselves. Instead, they wanted to clarify it is Congress. Because why? Because it is Congress who has our elected representatives sitting there. Let's go back again and look at the opinion. It says Section 3 works by imposing on certain individuals a preventive and severe penalty, disqualification from holding a wide array of offices. It is therefore necessary to ascertain what particular individuals are embraced by the provision. In other words, the entire 14th Amendment is about protecting individuals from state governments, state entities. To accomplish this ascertainment and ensure effective results, proceedings, evidence, decisions, and enforcement of decisions, more or less formal, are indispensable. There must be some kind of determination that Section 3 applies to a particular person before the disqualification holds meaning. And then it went on to say, Section 5 limits congressional legislation enforcing Section 3 because Section 5 is strictly remedial. To comply with that limitation, Congress must tailor its legislative scheme to remedying or preventing the specific conduct the relevant provision prohibits. Section 3, unlike other provisions of the 14th Amendment, prescribes conduct of individuals. It bars persons from holding office after taking a qualifying oath and then engaging in insurrection or rebellion, nothing more. Neither we nor the respondents are aware of any other legislation by Congress to enforce Section 3. Okay, so let's go back to the 14th Amendment. Let me share that with you one last time so you can understand. Let's see here. Okay, so remember, the 14th Amendment, it prohibits a state, a government, from depriving any person life, liberty, or property without due process of law. That's the big kicker here. Big kicker here is the Supreme Court is enforcing and protecting individual liberties. And it is concerned that the executive branch of government would try to deprive an individual of his or her rights without due process of law. Okay. First, to have due process of law, you must have a law. It must come from the legislative branch. And they don't want the executive branch of government usurping that authority of the legislative branch. And so that's why I think that's why they emphasize that. Okay, I hope that is helpful to you. If you have any questions about it, go ahead and make a comment, and I'll try to respond to that. And if you like this video, please click that like button. If you find this helpful, subscribe. Let me know that you find it helpful. Let me know that you're interested in seeing more videos like this. And if you want to see more videos and know when I update them or stream, go ahead and click that bell so that you can be notified when we do another stream. That's it. Again, I'm Coach Tate with My Court Coach. If you are going to be presenting evidence in court, or you're going to be testifying, or you're going to be presenting argument in any court throughout the country, in any courthouse, in any type of case, you would need some help. If you're not going to have a lawyer representing you, you're going to be pro per or pro se, you should get some help. And our help is the Full Court Preps. It's an online program that helps you learn how to organize your case, how to prepare your case, and then how to present your case while you're standing in front of the judge. Go to mycourtcoach.com to learn more about the Full Court Preps. That's all for now. I'm signing off. I hope you have a good day.